Hi, can you hear me? Okay,
Yes.
shall we start? Okay, welcome to our, okay. Welcome to you all have good lunch. Okay, this afternoon. Today we will do this case study for Dato' Suda against Menang Kopke, Malaysia Berhad. It's a case. Anyone speaking there?
Yeah, your line is breaking.
Okay, if you can't hear me, let me know, yeah. Or I'm talking line breaking. Okay. Can hear now?
Still same.
Can you hear me now?
Still the same.
Hello?
Still breaking.
Hello?
Hello?
Can
Your
you
line,
hear me now?
your line still breaking.
Still breaking. Oh. Yes, yes. I can hear you all. My line still breaking.
Yes, your line is breaking.
Clear. How about now?
Hello?
Can you hear me now?
Okay, better.
Hello?
Hello? Yes, now
Hello?
better.
Can you hear me now? Still breaking. I'm trying to change. Yes. Can you hear me now? Okay, okay. All right. Okay, I'll do just we straight go to case study. Okay. Discussing this case, Dato' Shun Leong, it's a case in 2001, somewhere in it was actually this of directors. Okay, this news was reported on.
Hello, Miss Boyi, we can hear you. Hi, Miss Boyi. We can hear you.
Can you hear me now?
Now can.
Can I? Sorry for the line. Okay, so we go to the facts of the case. Okay. In this case, the first plaintiff, Dato' Sun Leong, is the substantial shareholder of the first defendant. Okay, since 1989, holding about that much share, 16,000 shares of the first defendant. First defendant refers to the Menang Corporation. Okay, and our first plaintiff.
Miss Boyi, sorry, your slides just now.
Why?
Your slides.
Like this.
No, we can. You haven't shared your slide.
Okay. I haven't shared my slide. Okay. Belum. Yeah. now? Hello, can you see now?
Can see, but your line is breaking.
I can see me now. Okay, the facts of the case. Hear me?
Your line is breaking. Ms. Poyi, your line is breaking.
How about now?
Yeah. Can you put your slide in presentation mode?
Okay. Can you hear me now?
Can.
Okay. 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 First plaintiff is the shareholder, Dato' Sun, is the shareholder of the first defendant. Okay, we continue. Okay, the first plaintiff wife and the son was also shareholder of the first defendant. And the second plaintiff is the daughter of the first plaintiff. Okay, so it's a father and daughter, first plaintiff and second plaintiff. Both of them are also director of the first defendant, the Menang Corporation. Yeah. So there's dispute there, okay, arose from a tussle for control of board of directors of the first defendant.
Ms. Poyi, sorry, your slides.
I already shared that.
Missing.
Missing.
Okay, now can see.
Can you see now? Okay. So dispute arose, okay, from a tussle for control of board of directors of the first defendant. So there appears there to be two factions, okay? The plaintiff factions, the first plaintiff, one faction, and the second to the fourth defendant is another faction, okay? Okay. So this tussle already started, okay, somewhere in 2020. And arose from that tussle, the first plaintiff commenced an action against Dato' Lee in a separate suit, okay, an earlier suit number 84. They're seeking for specific performance of an agreement entered between both of them to manage, okay, the board of directors of the first defendant and to purchase the first plaintiff shares in the company. Okay, we call that 26 January 2021 agreement. Okay. So on the 29th January, 3 days later, there was a reshuffle, okay, appointment of a new directors to the board, okay, of the first defendant, including the plaintiff, the both plaintiffs as independent non-executive directors. So in February 2021, okay, so it was the board of directors of the first defendant was redesignated, as you can see below. Okay, so where the plaintiff, okay, Dato' Sun and Mariana, the daughter, they are non-independent, non-executive director. So on February 2021, there was a memorandum issued by the company showing that there were some irregularities, okay, by the plaintiff. And these irregularities, alleged irregularities, resulted in suspension of the plaintiff by the board of directors of the company on 15 February 2021. Okay, actually this suspension was also reported in the Edge newspaper. Yeah, on 2 days later, there's a notice issued, okay, to schedule for meeting, okay, an audit meeting, okay, and also a board meeting. It was scheduled on the same day on 25th February 2021, but only the notice for the board meeting, the second one, was forwarded to plaintiff. The audit and the risk management meeting does not include plaintiff. All right. So there was 2 meeting links, but only the board meeting link was sent to the plaintiff. Okay. So 5 days later, on 22nd February, Dato' Lee issued a notice to request for an EGM. Actually, one of the agenda is to remove plaintiff as directors of the first defendant. So on the 25th of February 2021, okay, where the 2 meetings were supposed to be held, okay, but plaintiff is supposed to attend the board meeting, but they could not log in, okay, even though the meeting link was provided to them. So the board meeting proceeded, okay, the meeting proceeded, okay, without plaintiffs there, and whereby there was a resolution by the board that to fix the EGM, okay, as requested by Dato' Lee earlier. It was fixed on 30th March. All right. So on 16 March 2021, the first defendant issued a director's circular resolution to confirm the decision made on 25th February. Sorry, yeah, it was February 2021 to confirm the meeting, the decision made by the meeting. So on the 18th March, the 7 directors approved the circular resolution, except the 2 plaintiffs, right? And EGM were duly fixed, okay, pursuant to the resolutions were carried out, okay, and fixed on 30th March. Okay, so the plaintiff filed this suit to apply for declaration that to declare that the suspension of them as directors of the first defendant is null and void, and a declaration that exclusion of the plaintiff from the board meetings is unlawful, okay, and decisions made by the first defendant without presence of plaintiff in, okay, any decision made by the first defendant without presence of the plaintiff will be null and void, and injunction to restrain the defendants from adopting the decision made by the first defendant, okay, without presence of plaintiff, and for assessment of damages. So the plaintiff case, okay, their reason for filing is that a company who is not satisfied with its directors, okay, can go by way of this, there's a section, okay, 206 under the Companies Act to remove a director, no need for stay, okay, to remove. Because there's a safeguard under section 207 that there will be rights, okay, for the directors of the public company to be heard. So neither in Companies Act 2016 or the Articles of Association of the company expressly provides for suspension of a director. Okay, so in this case, the Articles of Association doesn't provide for suspension. Companies Act also doesn't provide for suspension. But the defendants argue on the other hand is that yes, Companies Board, the first defendant's Article of Association and the Companies Act may not have the express provision, but it can somehow be implied. How to imply? One, okay, is by Interpretation Act, section 1948. Okay, section 47 of that act says, okay, where that includes a power to appoint, that will necessarily includes the power to remove, to suspend, to reinstate, okay, and to, reappoint, okay, or reinstate. And second argument of the defendants, okay, is under section 211 of the Companies Act. It's called the necessary management power, okay? Though it does not expressly state, okay, power to suspend, but the business and affairs of a company shall be managed by a direction of a board. So the board must necessarily have all the powers necessary for managing, okay, the affairs of the company. So that impliedly must include the power to suspend. So that's the argument for the defendants, okay? They refer to the case of Dato' Ibrahim Petra against Petra Perdana, okay, in 2007. It's a federal court decision. So that's the argument for both parties. Yeah? So court has to decide these 2 questions. First, so whether before the facts presented, the facts as laid down, whether the first defendant in this case has the power expressly or impliedly to suspend the plaintiff as directors, okay, pursuant to Article 110 of the first defendant's constitution. Okay, if the answer to this is negative, means defendant has no power to suspend. So what is the effect of the decision of the board of directors to call for the EGM? Okay, so these are the two issues that need to be decided by the court. So parties keep mentioning Article 110, so we need to have to look what is the provision of the Article 110 of the Articles of Association. So it states there, directors shall have the power to appoint any person to be a director, either to fill a casual vacancy or addition to the existing directors. And such director shall hold office until the next following AGM and eligible for re-election, but shall not be taken into account in determining the directors who are to retire by rotation at such meeting. So you see Article 110, nowhere does it mention power to suspend, right? Okay, Section 208, okay, sub 4 of the Companies Act states that, yes, who's calling that? Mazatu? I continue, yeah? Okay, Section 208, okay, of Companies Act states that if a vacancy is created resulting from circumstances referred to subsection 1, the board shall have the power to appoint any person to be a director to fill the vacancy, okay, and such of a director shall hold office, blah, blah, blah. Okay, so the first defendant's argument is that, okay, the source of such implied power comes from the appointing power of the board, because Section 208, okay, says that we have power to appoint. So it must necessarily be implied that they also have the power to suspend, okay, to remove, to suspend. That's the argument of the first defendant, yeah. So what did court find? Okay, what did court decide? Okay, first, the Interpretation Act first, yeah. According to the Interpretation Act, okay, this applies only to written law. Is an article of association of a company a written law? Okay, the court says, okay, the new Companies Act 2016 does no longer make it mandatory for a constitution to be incorporated. Okay, I mean to be included for a company, right? In contrast with the old Companies Act, because old Companies Act is mandatory. A company must have a constitution and articles, but the new Companies Act, not mandatory, okay? So the Interpretation Act does not assist in interpreting the first defendant's constitution and the article. So article in this new Companies Act, okay, is not a written law. So if it's not a written law, Interpretation Act cannot apply. So that's the court's finding, yeah? Okay, what about the Companies Act provision? Okay, Section 211, okay, is a comprehensive act of parliament. Okay, every single detail is written in the Companies Act. It's a thick act, okay, thick statute. So it has specific provisions governing power of a board and its directors. So the court does not agree that the power to suspend can be implied, given the extensiveness of the CA. It's not like a thin act, okay, containing 3 or 4 sections where most of the provisions will be up to interpretation by the court. But Companies Act is a comprehensive, every single detail is inside already. Okay, if it's meant to be enacted, that means it's meant to be provided, it would have said so. Okay, so, and further, the companies, the first defendant's articles of association itself did not provide for a power to suspend. And articles of association, as we understand, is based on, is a contract, right? It's based on intention of the parties. So the court here has no power to improve the terms of AA. AA is articles of association. If it's not there, court cannot, okay, put power to improve on the terms. If it's not there, it's not there, right? So actually in court's finding here, there's 2 fractions of case presented by both of the parties, right? two factions of case. One case, Fong Po Yok's case says implied, yes, necessary managing power must include power, okay, must include that power to suspend, okay. And Kwan Teck Hian's case, on the other hand, says no. If it doesn't have that provision, means no, okay. Yeah. If Articles of Association doesn't have that provision, means no. No means no. So the rationale in Kwan Teck Hian's case, okay, is that unless, okay, expressly provided in the M&A, the suspension of director cannot be implied. It cannot simply imply, okay, things to an something that's been agreed. Okay, and also bearing in mind, a director, okay, is also have their own, also have duties as directors act. If you suspend them, that will prevent him from carrying out these duties, which may render him liable to breach of fiduciary duty. Okay, that's another offense, but that is not discussed. Okay, so that's the argument, the rationale in Kwan Teck Hian, which court by. Okay, for as the Companies Act 2016 does not expressly provide for suspension of a director's suspension will also not be recognized by SSM. If it's not recognized by SSM, okay, meaning SSM would not remove the name. It will still appear on the SSM's record as director. Okay, so if third parties and outsider do a search with SSM, it won't bind third parties. It will still appear as, the name will still appear as director. Okay, now, so there are also other remedies available to deal with a director who has not acted in the best interest. Okay, you have other options, such as, okay, you file legal action, you get an injunction, okay, you get other reliefs that the court can grant, and suspension is not one of those remedies. Okay, so any power to restrict the power of a director must be based on clear, specific legal provisions. Okay, so it's power to suspend versus power of director to perform. They still have duties to perform. Because if you suspend, it's like neither yes or neither no. Okay, they're still director, but they cannot exercise their duties. So therefore, question 1, okay, whether the company has power to suspend, okay, based on these facts, its answer in negative means no. Okay, no. So next, question number 2. Okay, if question 1 is answered in the negative, if question 1 is no, okay, what is the effect on the law? Okay, on the board of directors' decision, including the decision to call for EGM. So the plaintiff in this case, his case is that the first defendant has unlawfully suspended the plaintiff as directors and exclude them from the board meeting on 25th February, where they say they cannot log in. Okay, they say plaintiff intentionally do that. Okay, why the court has to make this finding, whether it's intentional or not intentional, because both has the effects. If the plaintiff suspension from, the exclusion from the board meeting is at the board will be a nullity. Okay, if the suspension, that means the exclusion from the board meeting was unintentional, it could be a mistake. Okay, the decision made will be a mere irregularity. If it's a mere irregularity, it is something that can be corrected, can be rectified. So that's the difference there. So the board has, the court here has to decide from the facts here whether the first defendant deliberately exclude the plaintiff from the meeting or it's a mistake. Okay. So plaintiff argument is that it's deliberate because plaintiff exclusion explanation, okay, it says there is a mistake, but plaintiff say this one is an afterthought, not true, not true. Okay, and further, the second plaintiff, which is the first defendant's first plaintiff daughter, they has informed the company secretary of the first defendant, okay, that they protest the board papers has been deliberately withheld from them, and such action was unlawful. Okay, and that the notice of meeting states that meeting to be held virtually online, but actually the meeting took place in office, okay, where the other directors were present. The first defendant's argument, on the other hand, is that no, I have given you the link, okay, have been sent to the plaintiff, okay, notwithstanding the suspension, and that they had never instructed the company secretary to exclude the plaintiff from the board meeting. Okay, so that's both parties' argument. So from the facts of the case, the court inclined to accept the first defendant's explanation. Okay, the plaintiff actually were inadvertently excluded. What happened there is that there was two links. Okay, so they started with the audit meeting where the plaintiff were not invited. Okay, so after the audit meeting, they're supposed to start with the board meeting, which plaintiff is supposed to attend. But instead of using the link they sent to plaintiff, they say, okay, because the attendees are more or less the same people, so they continue to use the first link, the link that they will use for audit, to continue with the meeting, explains plaintiff to the plaintiff why they cannot, inadvertent mistake. Okay, it's a genuine mistake, not intentional. So these findings, so the court said that the plaintiff exclusion from the board meeting is only a mere irregularity, which can be rectified. Okay, for this, the court referred to the federal court case of Lee Tak Suan against Tunku Dato Sri Shahabuddin, okay, 2009, which held that if some irregularity has been committed, it would be quite possible for a legal entity by means of further meeting and the like to make regular what apparently is irregular. Okay, so it's possible if it can be regularized. Okay, so based from the facts, okay, since the plaintiff has been inadvertently excluded from the board meeting, it can be cured, and actually it was cured by a subsequent meeting. You remember there's a circular resolution in March, okay? So it was circulated to all the plaintiff, all the directors, including the plaintiff, but the plaintiff didn't sign, right? The first defendants has issued on director's resolution, circular resolution on 16 March to affirm again the decision made on 25th February, but the plaintiff did not sign the resolution. Okay, so the plaintiff did not object, but they did not sign. Okay, and the DCR, the director's circular resolution was approved by 7 out of 9 directors, except that the two plaintiffs, and were duly carried out. Okay, so court found that the irregularity of the board meeting on the 25th February was duly rectified. Okay. So the court agreed with the first defendant's argument, okay, inevitable outcome, meaning inevitable outcome whether the plaintiff come or not, okay, on the 25th February, the outcome would be the same because it would still be approved by 7 out of 9 directors. Okay. So notice of requisition meeting, this one is another point, okay, is sent by a shareholder, Dato Lee. Okay, he's a member of the company. So request for an EGM. The first defendant, they will have no discretion. They are required under section 311 and 312 of the Companies Act to fix that meeting accordingly. Okay, it's not up for them to decide they want or not. Okay, there's a request for meeting, they have to fix that meeting. So the court referred to a court's another case, Court of Appeals decision in Abdul Rahim against Krubong Industrial Park, okay, 1995 case, where it says that the court will not interfere with internal workings of a corporation upon a matter which is capable to be ratified by a majority of shareholders present and voting at the general meeting of the company. Okay, if it's capable of being ratified, court would not interfere. Because this is also in line with an English case, okay, Force and Harbottle, okay, which is quite one of the principles is that court will not interfere with internal workings of a corporation if the decision of the company is capable of being ratified by a majority of shareholders. Okay. So in this case, the court allowed, okay, prayer 1, where the suspension was unlawful because it was held that first defendant no power to suspend. But for the rectification, yes, there's no issue on that. So it was dismissed, right? And damages, of course, to be assessed. No orders to cost. Okay, so the takeaway from here is that I would just summarize as this. A company is not prohibited from providing for suspension of directors in its article of association. Okay, but the power must be exercised very carefully, bearing in mind 3 things. Okay, such suspension does not bind SSM and outsiders. Okay. Second reason, directors have their duty and power, okay, duty to perform. Therefore, suspending them may render them be liable. For breach reason, there is other relief available to a company to deal with wrongdoings of a director. Okay, filing court action and getting the interim injunction or interim relief. Okay, so suspension is not one of those relief. Okay, so that's my sharing. Is there any comments or questions or clarification? Yes. Stop sharing, yeah. Any questions? Any comments? Oh, thank you, Ms. Scott. Okay, if no, then I thank you for all who attended. Okay, hope you benefit from this sharing session. Okay, so because I think corporate law is one of the Companies Act, one of the important acts that we, especially the CC teams. Okay, the CC team, yeah. So this is one thing of they can learn together lah.
Oh, you send me the slide since I'm late.
Can.
Thanks.
Can.
Okay, can. Yep.
All right. Okay. So thank you for attending. Yeah. Okay. Take care.